our speaker is Dr. Teresa Reguly. Teresa completed her PhD at the University of Toronto in the Department of Molecular and Medical Genetics before going to law school, also at the University of Toronto, and she is now a partner at Torys LLP in Toronto, where she works in the Intellectual Property and Food and Drug Regulatory Law Group. If you have questions for Teresa, she's told us that she's okay if you interrupt her, but we'll ask you to please type them in the chat or maybe put up your hand in Zoom and I will moderate all that. So I will moderate the chat and I will make sure your questions get answered. And that is it for me. So thank you, Teresa, for joining us.
Perfect. Okay. Thank you, everybody. And thank you for your patience as I deal with the technology. So yeah, as Leslie said, you know, I put together some slides because I thought, you know, always good to have something to look at other than heads on the screen. But I'm very flexible if anyone wants to ask questions or go off topic. You know, please don't hesitate to put your question in the chat, and we can have a discussion that has nothing to do with what I'm presenting, or get into a little deeper with what I'm presenting. But I want to thank Leslie and thank all of you for inviting me here to speak today. You know, I don't talk about myself very often, so bear with me if I'm forgetting some of the details of my past life to try to explain to you how I got to where I am. But I thought today what I do is just kind of take you through my education, my training, you know, how I decided to become a lawyer, or more how I fell into becoming a lawyer, and sort of how my scientific background, you know, I still do use today, even though I'm certainly not a scientist anymore, but it still comes in handy with the kind of clients that I service and in my practice today. So with that, just briefly, so, you know, as Leslie mentioned, I have an undergrad as well as a PhD in molecular genetics. While I was doing my PhD, I you know, decided that I didn't think, you know, being a hardcore scientist was the path for me. So that's when I started thinking about other options. And the one I chose was to go to the University of Toronto for law school. Once I finished law school, because I went into intellectual property law, which we'll get into, I also wrote a set of exams so that I'm a licensed patent agent as well, which is, you know, not something that's required to be an IP lawyer, but I would say that a significant number of IP lawyers also do these tests so that you can call yourself a designated patent agent. And then I was telling Leslie I had to include her. You know, my formative years were spent on a bench very close to Dr. Leslie. So we both worked together in Dr. Rana's lab at Mount Sinai Hospital at the time. And I also worked on C. elegans, which was what she was working on at the time as well. So she taught me everything I know about picking worms and making sure that the nasty bacteria doesn't grow on the plates, which it's always fun for me to think about those times. And I had to like look up like what was my PhD on. I'm like, you know what, I'm not even going to put it in the slide because it's been so long I forget the title. But I was involved in, you know, signaling pathways. TGF beta was Jeff Rana's focus at the time, and that's what we were all working on. So did the PhD, and then, as I said, I kind of knew I didn't want to stay on the bench. Didn't know what I wanted to do exactly. And funny enough, another friend of Leslie and mine was thinking about law school. And I hadn't thought about it, quite frankly, before that time. And she said, well, write the LSAT, see how it goes. If you hate it, you'll do a postdoc. I'm like, okay, sounds good, Allison, let's do that. So I embarked on this path. Okay, I gotta, you know, haven't written exams in a while, and studying for the LSAT was an experience. I ended up writing it twice. The first time I didn't do terrible, but I certainly didn't get, you know, the marks I wanted if I did want to go to U of T or you know, a school like that. So I ended up writing it twice. And really the key with this exam is timing. So you know, it's not that you could figure out all the answers if you had 4 hours to do it, but you only have, you know, about 40 minutes per section. So it's really like practicing and, you know, going back to more almost high school and undergrad days in terms of how to study for that. But you know, that's a big part of it. So you have to write the LSAT. You get certain marks. Most schools have like a threshold. You have to get above a certain average on the test before they'll even look at your score. And then they also look at your undergrad, and in my case, PhD numbers as well. So, it's the kind of, depending on what school you want to go to, like the grades that you're getting in your undergrad versus and PhD are, more important in some cases, less important in others. I think if you're applying as a PhD or postdoc, you're probably going to be looked at a little differently than the undergrad. So that gives some flexibility in terms of, what I'm trying to say is, don't think that if you don't have, straight A pluses, there's no chance you can go to law school, because that's not the case. Try to do good on that LSAT and have decent marks. And then once you kind of get past that hurdle, I think anyone who has an advanced degree is something of interest to most Canadian law schools. And so then once I got into law school, I chose U of T mainly because, my husband, my family was here and I didn't want to go far. But there are, there's good schools across Canada, so don't think that Toronto's the only place where you can go. Once you get into law school, every program's a little bit different, but generally, like the first year of law school is an introduction to the key areas of legal practice. So you'll learn about the Constitution, which I as a scientist had never thought about until I stepped into that class for the first time. You'll learn about criminal law. Like again, it's everything you see Law and Order on TV. You'll learn how in Canada all those rules don't quite apply and things are a little bit different. And then contracts, property, legal writing. So you kind of take these general courses in your first year. And then in your second and third year, it's a little more specialized. So that's where you have more of an opportunity to take courses of interest to you. And also, quite frankly, you're trying to take courses because you're going to have to write a bar exam after third year. So even though I didn't really have an interest in real estate or family law, those are probably courses you'll take in law school just so you know enough to pass the bar exams when they come around. But the one I've highlighted there is, of course, intellectual property, because that's kind of where I ended up. I'll say at that point in my life, everyone told me that because I was a scientist, oh, you should do IP law. And I said, yeah, because I'm a scientist, I'm going to do that. And I really didn't have a good understanding of what that was until I actually started practicing in the area. So the point of law school is, like, they really do want you to take classes here and there, figure out what you like and don't like. And then, hopefully you do find an area you do like, and you kind of start to specialize when you get to third year. So in Toronto and in the other big cities in Canada, when you're going, the large firms, corporate law firms, they go to law schools and they recruit you, to come in first as a summer student, and then hopefully hire you back as an associate lawyer. And so that's kind of the process that I went through that got me here to Torys. So in between your second and third year, the summer that starts just before your second year of law school, you'll start doing your applications for this process. We call it OCIs, on-campus interviews. So you apply, and you'll get a list of firms that are interested based on your cover letter and your resume, and they'll look at your marks as well. They're interested in coming in and interviewing with you. And they come to you in the first round, and it's kind of like a bell ringer. And when I did, I think it was 12 minutes, 12 minutes a session. So you'll probably meet with like sometimes 10, 15 different law firms in a day, and you're kind of circling around the convention center, going from like booth to booth, meeting with representatives from the different firms. So if you get past that OCI stage, then a group of candidates are then invited to come to the firms for more formal interviews, where you'll meet with a variety of people at the firm and actually talk to people who are in practice areas that you're interested in, try to wine and dine you a bit. Like, before COVID, we would take students out for dinner and have parties, and that then we went virtual for a couple of years. We haven't actually done that. Hopefully this year we come back. But yeah, it's an opportunity to get a sense of the firm, meet more people there, see what things are like, meet students as well as partners, and just see if it's the kind of place where you think you might be interested in working. And not all firms do this. So, you know, there are certainly like students coming out of law school who don't go through this process either because they don't want to, or you know, they may not be successful, so they don't find a firm that offers them a position for the summer. So that doesn't mean, you know, you're never going to get a job. Like, don't think it's like that. This is an easier way to get in. It's easier for the firms to meet a lot of people all at the same time. But there's lots of students that will find a job, you know, at a firm that didn't participate in the process, or just, you know, naturally get hired on when they've actually completed their third year of law school. Before you actually start work, you do have to go through this process of writing the bar exam, and then we have a year that we call articling. So the bar exam itself in Ontario, you know, it's an exam. It's not fun, but it's not ridiculous in terms of the amount of studying you have to do, or the, you know, the pass rate. The pass rate is fairly high. I believe it's over 90% historically. You know, it's open book, although I should pause there because they change it from year to year. But you know, when I wrote it, it was certainly open book, and you come in with a whole bunch of materials and you're flipping through. And again, it's more about timing, making sure you can get through all the questions in the amount of time, because it's a substantial amount of information you have to digest. But yeah, it's something you have to do, but it's not something you should be scared of, because if you've, you know, been through law school, you'll have a sense of what it's like to take those exams again, and you'll know, you know, the kinds of questions you expect. There's lots of practice exams and, you know, ways you can prepare for it. So then once you do the bar exam, you are required in Canada to do this 10-month articling. You think of articling as like an internship, so it is paid. But the structure of it is overseen by, you know, by the Law Society, because they want to make sure that, you know, if someone comes into a firm, or even if they're working under a single lawyer, that lawyer is acting as their mentor, making sure that they do see different types of areas of law. Sorry, my thing just popped up there. You know, making sure that they're exposed to different types of areas of law, different types of matters, and they're getting like a well-rounded 10 months of what it's actually like to be a lawyer. You know, at a place like here, Torys, we tend to hire somewhere between 20 and 25 students each year. Again, it varies from year to year. But often if you're at a big firm, you're kind of coming in with a class. You know, it feels like you're all in this together. It's actually nice to have, you know, these are going to be your friends for the next many years. It's sort of nice to come in and have a group that they're all in the same boat as you, and you know, you can rely on each other to help you out and help with the learning process. So that's always kind of nice. Most firms, so it used to be back in the day, like even before I went into law, if you got an articling position at a firm, it was automatic hire back. Like it just used to be a rule, which is great, because, you know, you did your 10 months and then you knew the firm would hire you back for a position. That's changed now, so you know, there is no requirement that the firm hire you back after they've worked with you through articling. It depends on which firm, like what the rate is. Like, again, like historically here at Torys, we're usually 90-95% hire back. You know, there's usually the students that don't get hired back. It's not that they don't get hired back, it's that they choose to do something else. So they might go clerk at a court, or, you know, find another opportunity. Whereas other firms, you know, their model is they actually bring in, you know, a ton of students, and they don't necessarily hire them all back. So they might only hire 50% back, or, you know, whatever it works out to that year. So that's, you know, if you ever get down this road, I think those are like questions to ask during the interview process, because it just gives you information probably before the interview process. Like it's more, you know, doing your market research on who you're meeting with, and, you know, what's the likelihood that they're going to take you on afterwards, just so you know what you're getting yourself into when you do pick your firm. So I went through all of that process. With my OCIs, I interviewed at both kind of smaller firms that are specialized in intellectual property, where that's all they do. We call them boutiques, because they have one area of law and they focus on that. I also interviewed at many, I would call them full service corporate firms. So a place like where I am now at Torys, where, excuse me, we have a variety of practice areas, and intellectual property, is one of them, one of the core groups here. I did that on purpose because, as I mentioned a few slides back, everyone keep telling me that I should be an IP lawyer, but I didn't know if that's what I wanted to do because I didn't really know what that meant at the time. And so I thought that's what I wanted to do because it all seemed to make sense. If I can keep using my science degree, that seems like a good thing to do. But I didn't want to, close doors on other things just because there was a world of things that I didn't know. Not coming from a family, there were no lawyers in my family. I don't even know if I knew any lawyers at the time. So that's why I chose a full service firm. And, I do think it really worked out in terms of my growth, my practice, and getting from my point of view anyways, I feel like I work with a really interesting variety of clients and have a variety of issues come up that I may not have had the chance to tackle if I was at a more focused smaller firm with a more focused practice. So our firm Torys, our main office is here in Toronto, where I'm located. We also have offices in Calgary, Montreal, New York, and Halifax. We have about 400 lawyers in total across all of those offices. And then, we have a lot of staff as well, so non-lawyers, our secretarial staff, IT, business services, all the things that you need to keep a business operating. So we probably end up employing at a whole around 700 or 800 persons from any point in time. And so I think I did why I picked Torys there. So just to give you a sense of what Torys does, like I've taken most of these from our website, so you can definitely go there for more information. But I was just trying to give an overview of we're a full service corporate firm. So our clients, what that means is our clients tend to not be individuals, although every once in a while we do have a client who's an actual person. Most of the time our clients are a company, and they could be a company that is an operating company, so a company that's actually buying, selling, doing things. And I would say those clients tend to be more my clients, coming from the IP and regulatory product space. A lot of our clients are, in the financial services. So they're banks, they're pension funds, they're investors. And I work with those clients as well from the point of view of, if you're investing in a business, what would you like to know about that business before you put a lot of money into it and, decide whether you actually want to be an owner of it. As I said, I did say we have a few individual persons who are our clients. In my world, sometimes those persons, they tend to be, a doctor at Mount Sinai Hospital, or an inventor at a university who, for whatever reason, they're not using the normal tech transfer route at their institution. They have an idea for a patent, and they have the money and they want to go it alone. So we do have a few of those kind of soul inventors and persons that we also support here with our client base. And this slide is just the different industries. So again, because we're a full corporate firm, we work in all different industries, right? Oil and gas, mining, infrastructure, fintech. The ones I've circled are the ones that I work in, which is our life sciences practice. So, those would be companies that, have a drug product, a medical device, something of interest to the healthcare system that they'd like to commercialize. Also, I've circled there cannabis. That was a less of a big deal now, but back in like 2018 when we first legalized, there was so much interest in that area. Again, from everyone, people who wanted to sell it, people who wanted to invest in it, people who wanted to stop it from getting out. So, and it is a Health Canada regulated product, the way drug products are regulated. So it sort of fell to our group to learn the rules around there. And the other area circled there is like consumer and retail, which is a big bucket. But again, companies that are selling regulated products, they'll have issues with respect to trademarks. They'll have, sometimes when they're consumer products, they are under patent as well. And there's all kinds of rules, depending on the kind of product it is, there's all kind of rules about advertising and who you could sell to. So that's where I get into it as well. So the next little bit, I just thought I'd talk a little bit, very high level, about like what intellectual property is, like what I'm doing from a substantive level every day. So intellectual property, if you think of real property as, something tangible, my computer, my house, something I can buy or sell. Intellectual property is not something we can touch in that way, but certainly something that has developed in a way that there are rules around ownership and how to value it, and there's rights in it, like who has the right to use it, who has the right to control it. And so that's what you do as an intellectual property lawyer. There's different kinds of intellectual property. The one I focus on is patents, which probably conceptually is most familiar to all of you. If you discover a new molecule that seems to be doing something great in the dish, could this be a drug candidate, right? So it's the inventive concept that you've come up with a new molecule, or you found a new use for a molecule, and it seems to have some use that will be useful from a commercial perspective. That would be something you'd look to see patent protection on. Other types of IP, copyright. I don't do very much copyright. I think if you were a lawyer in Hollywood, you'd probably have a lot of that kind of business. Software is subject to copyright. Again, not my area, but if you're a software tech lawyer, you'd be more involved in the copyright aspect. Industrial designs they're sort of the sister to a patent. So a patent is all about an invention, the spark of creativity, not the look and feel of a product. It's the function, what makes the product unique. Whereas industrial design, the uniqueness is literally the look and feel, like the aesthetics of it. And so in consumer products, industrial designs can be utilized quite a bit. Like if you think of something like new dinner plates, or items that you'd find if you went to Canadian Tire or a place like that, like for your garden. It looks a little different this year than it did last year. What they do is they literally file the shape and design of that so that other people can't market those same products. Trademarks are probably very familiar to most of you as well. Trademarks is about branding and establishing goodwill in the brand, whether it be the name or a logo, something that identifies your business and your products with the mark. Trade secrets and confidential information is another area of IP that's it's not a registrable IP, so it's not something you can, you don't write down your trade secret and file it with the Canadian Intellectual Property Office. What you do instead is put measures around your business to ensure that it remains a secret, so other people don't have access to that information. If they leave the company, there's very strict rules on them not taking that information with them. So you sort of protect it as a secret, as opposed to being a patent. Patents get published, right? So it's kind of like a give and take. Like patents give you certain rights, but you have to disclose to the world, this is the invention I came up with the idea being that other people can use it after your patent expires. Whereas trade secrets, you can keep things as a trade secret for hundreds of years, as long as no one lets that secret out. It's something that has value, and it's something that can be valuable to investors looking to go into your business. I think this slide kind of just took you through everything I just said, just with some more graphics there. So I'll just skip over that. I'll talk a little bit about like getting a patent and really what I do as a patent agent. So I'm speaking with inventors who've come up with this idea, right? So I have the first part here in green because that's what the inventor does. The inventor has a great idea, and they come to me and they tell me this great idea. They have the concept, they've done some testing, they use the term like reduced to practice, like they've actually worked the invention and they can explain to me how it works. And then we'll have a discussion about whether it meets like the basics for patentability. So there's lots of great inventions. Doesn't necessarily mean that you would get a patent on them. And patents they're expensive, right? They're not so expensive in the beginning, like doing the first couple of steps. But if you want to actually seek patent protection in every jurisdiction and keep that going for the 20-year term, it gets expensive because you have to pay maintenance fees every year. You have to, if you're filing in Asia, you're going to have to translate all your documents into another language. And so that's why it's when it's a small inventor in particular, we have a discussion at the beginning about, does this make sense for you, knowing knowing where things might go, and are you going to be looking for a business partner or some kind of investor to help you out once you get a little along the way. So that's kind of the step one. And then if the inventor decides like, yeah, I want to go forward with this, then what we do is we help the inventor. They're telling us how the invention works, and we're sort of translating that into patent speak. We draft the patent application to cover, exactly what they've invented, as well as iterations, and kind of broaden the scope of it so they can get as much protection as possible over the literal thing they've made, as well as variants of what they've made, and how broad scope they get from their patent is really going to depend on what else is out there, which is what we call prior art, right? So if someone else has already come up with something similar, or sort of, they put a half-baked concept into an article, we have to work around that in order to secure protection for our client on the particular invention that they're wanting to bring to market. So you file this application. You sometimes are filing follow-on applications as more data is generated. You get to the point where you have to make a decision. Am I just going to be filing like in Canada and the US? Am I going to go internationally? And there's the whole strategy around kind of putting your stake in the sand and giving yourself as much time as possible, mostly to delay those fees. But in most cases, you're going to be filing in more than just Canada, because most businesses are selling a product in more than just Canada. And patents, as well as other things I talked about, trademarks and everything else, it's all region to region, right? So if you have a Canadian patent, it doesn't stop someone in the US from setting up shop there and making the same product.
We have a couple questions in the
yeah,
chat.
sure, go ahead.
Tracy.
Yeah, I can't see them, so yeah, please.
Okay.
Yeah.
The first one is, if you want to work in IP after your PhD, do you have to go to law school, or are there other methods?
Yeah, no, that's a great question. So everything I'm talking about right now, working on patents, you can be a patent agent without being a lawyer. So what that means, so a patent agent means that you have written these particular set of exams and you get this designation. We actually, just in the last couple of years, we have like a professional body that governs patent agents. We didn't until recently, but we do now. And so they kind of set the standards. They're changing the testing format, and they set the standards you have to meet in order to call yourself a patent agent. And you certainly can do that. And so to be a patent agent, part of the requirements before you can write that test, you have to find existing agents, like people who are already agents, to work with you. I think right now it's either 15 months or 18 months. So I can come back to you on that. But you have to have this period of time where you learn, right? You learn from an actual agent all the rules of the road, and how to do the job, and then you can write the qualifying exams, and once you pass them, then you can put up your own shingle and be a patent agent and do this kind of work without being a lawyer. I would say the difference with being an agent versus a lawyer, like it is limited to like the patent drafting, patent working with inventors to define what the invention is, going back and forth with the patent offices on the breadth of the invention, so how broadly coverage you're going to get, and then working with clients on like kind of the maintenance fees and sort of keeping their portfolio in place. You can't, it doesn't go past that in terms of like if you're interested in litigation or sort of other things you can do with an IP background, that would be where you'd want to think about law school, because it would just expand the type of work that you're doing on a day-to-day basis.
We have another couple questions in there.
Yeah.
Could you expand on the complementary areas of law that you focused on to supplement your primary specialty in IP? i.e., did you do a deep dive in securities, tort, contracts, business, etc.?
Yeah, so I would say, me personally, my practice kind of evolved in a different way. So I started in the IP group here at Torys. I was doing all IP and pretty much all patents, like, to be very specific. So I was doing patent drafting, patent prosecution. And through that, I learned, I got relationships with clients who are, the firm clients. They may have been drug companies and have been other, healthcare companies. I learned about their business by working on their IP portfolios. And it just kind of happened naturally, particularly in the pharmaceutical space. Like, IP and sort of the Health Canada regulatory marketing aspect are very tied. So I just learned more about not just protecting the invention, but all the steps you have to go through if you actually do want to sell a drug in Canada. How do you get Health Canada's approval? What price is it going to be set at? Who actually pays for it? Who are these insurance companies? What's reimbursement? So I kind of learned all that from doing the IP. And then in learning all that, I would say over time, my practice has shifted. So I still do IP today, but I would say it's much more at a strategic level. And most of the advice I'm giving to companies these days, they tend to be companies that have a lot of IP, but I'm giving them advice on how you can navigate the Canadian market to, what hurdles will there be? What opportunities will there be? Here's the things you have to keep in mind if you're going to be selling this product on the Canadian market. So I didn't really learn about securities law, but again, because I'm at a corporate firm and because we have securities deals coming through here, I understand the pinch points, I guess, how do you properly disclose in a prospectus when you're an early stage company, what the risks are of coming to market. So I can draft that part of a prospectus, which is a securities document, that tells potential investors, here's all you need to know about the company before you give us your money. I can write that portion of the prospectus that's about, drug discovery and all the risks, right? So many new molecules are discovered every year, but only, 10 get approved, right? So that kind of stuff. So that's how I would say I started very specifically doing IP only, and my knowledge grew as my practice grew, and it just kind of naturally grew into something very different than it was 15 years ago when I started.
Is there anything you did during your PhD that enabled you to stand out when applying to law school, or to summer positions and or articling?
Not that I can think of. At the time, there's probably more people now with PhDs going to law school. At the time, there wasn't a ton of us in Canada anyways. So in my law school class, I think there's 5 of us. And we all ended up doing kind of what I've been describing to you. We all ended up on a Bay Street firm that focuses on IP. I think the fact that you're a PhD stands out in itself. When you're trying to get into law school, I think having a PhD and even postdoc experience helps if your grades aren't great, because they have something else to look at, to see you're a well-rounded person. We're not just going to deal with your grades and nothing else, right? And then once you're in law school and you're going through the interviews, if you're interviewing to be a banking lawyer, maybe your scientific background doesn't help. But if you're interviewing and saying, as I did, I'm not sure what I want to do, but I think I have this interest in IP, I love scientists, love science, I don't want to leave that behind. Seeing that PhD there is quite meaningful. And I think I'm assuming the audience is all life science based. But
I think mostly, but we may have a few people who aren't.
Yeah. So, pharmaceutical patents are, hear what you might, like pharma's never going away, and everyone's going to keep trying to protect those patents. So you have very specific expertise that are needed for drafting those kinds of inventions. If you happen to be an engineer, software engineer, like tons of stuff going on in tech these days. I know literally nothing about how computers work, which is why we have people in my group that like only deal with that stuff, right? So depending on where you're applying to, and what's popular at the time or where they need space, like having that particular expertise is going to be very compelling to your future employer.
Okay, we got one more in the chat, and then we got a couple hands up.
Yeah, for sure.
Are there specific undergraduate or specific backgrounds that are more useful to know in IP law?
I would say, like, if you want to be a patent lawyer, like if you want to do patents specifically, it's getting more and more difficult to not have a science. Like when I say scientific, like either life science or engineering, like some form of science, and go into doing patents. If you're a trademark lawyer, like the trademark lawyers in our group, they don't have a scientific background. Most of them don't have. They've done an undergrad, but they didn't do any other degree before they went to law school. So it kind of depends what you're interested in. I know I'm talking a lot about patents because that's what I do, but there's other, certainly other things you can think about. But yeah, I would say, like, if you're, I wouldn't necessarily say it's impossible to become a patent lawyer if you don't have a scientific degree, but right now there's so many candidates, just from what I see, there's so many candidates that have one that I think it'll be difficult for you to get into that area if you didn't have a scientific degree. So I think it's not about taking a particular course. I think it's more leveraging the courses that I'm sure all of you have already taken to say, like, I have an interest in this area, give me a foot in the door. And once you have your foot in the door, then you kind of have more flexibility to figure out if there's another area of law that you might be interested in. Yeah. Okay,
Kyle, do you want to go ahead and unmute yourself and ask your question?
Yeah, thanks, Leslie. And thank you, Teresa, for coming today to discuss your background with us. Your first answer to the first question that I gave earlier in the chat actually kind of made me want to ask a follow-up.
Yeah.
And could you expand on the relationship that Torys has with respect to its clients, and in a sense of how much do you work with investment banks, for example? Like first one comes to mind is Bloom Burton, for example, here in Toronto, who is very active within the healthcare space, who offer very complementary services to that of an LLP, like a legal firm. And so could you expand on if there are complementary kind of services that both institutions provide, or do you work together for the client as well?
Yeah, no, and that's a perfect example because I was just at the Bloom Burton conference not that long ago. And yeah, in some cases, Bloom Burton might be our client because they are advising their underlying client and a legal issue arises, and they'd say, okay, let's bring in Torys, but the information sort of flows from Torys to Bloom Burton to the underlying client. In other situations, it's exactly what you described. It's complementary. So there's, business consultants that are helping companies navigate the business world. And then you have your legal team who's saying, yeah, like you have these two options. Here's the risk in doing this. Here's something you should think about. If you go down this path, there's certain conditions you're going to have to address when you get there. And they're sort of giving that legal advice to help both sides give the best advice to the underlying business to say, yeah, you know what, it's not the right time for us to launch in Canada. Let's try launching in the US first and see what happens, or whatever the question is they're struggling with.
Gotcha. No, thank you so much.
Yeah. Yeah, good question. I think you're on mute, Leslie, but I think there's someone else that has their hand up.
Yep, that was me. Do you want to go ahead? And unmute yourself, Mukbaya?
Yeah. Thanks, Teresa. Thanks, Leslie, and thanks also, Teresa, for your talk. So now that you're in the industry and you had done your PhD before, looking back, what would you say would, if you had tailored your PhD more towards what you're doing now, would that have been, is that advice you would have given yourself at the time you're doing your PhD? Or would you say that what really mattered was the fact that you built a set of skills during your PhD, which are transferable? And so, that's what you should focus on. So basically, I'm trying to ask, what should you really be thinking about more? Should you be taking the opportunity to build those transferable skills and broadening your understanding and horizons as such, or should you, at a very early stage, start sort of narrowing down your PhD to that area that you sort of think you want to be in? And so, what are the pros and what sort of trade-offs would you make, or would you, looking back, if you're advising yourself at the beginning of this journey? Thanks.
Yeah, no, that's a great question. Yeah, and I would say it's like the latter. Like it's not necessarily about your substantive, specific scientific knowledge. It's more about the fact that you have that learning, you're trained as a scientist. And I love the way you said it, like, what are those transferable skills, right? So just because you didn't go to business school doesn't mean you're not an incredibly smart cookie. You know how businesses work, and everything that you've learned during your PhD has helped prepare you to, be organized, attention to detail, excellent writing. Like we write all the time, right? Like, you don't have to be an English major to write. Like that's what lawyers do, right? And I know you'd be familiar with that as well, like writing publications, writing your thesis, all of that. So I think it's more about recognizing that you have those skills and communicating when you go through the interview process, how you're going to transfer those skills to, from the academic world to the business world. I guess just to argue the other point, like in Canada, less of an issue, just because Canada is such a smaller market. It's difficult to find someone with such specialized experience that you'd really say, like, well, that's the only person in all of Canada that can write a patent that has anything to do with stem cells. Like we don't have enough people or enough work really to be that specialized. In the US, it's a little different. Like there are some patent attorneys who literally write in that very, they only draft patents in that very narrow frame, and they know everything there is to know about, dealing with the US Patent Office to get the best claims possible. So I guess that's the other side of what I said. Like you can decide, like looking at the future, like I think this is an area where there's going to be thousands and thousands of companies that are making a product in this area. And so I want to focus my substantive scientific skills to learn more about those pathways that I know are going to be so important drafting patents 10 years from now. I would say that's not what most people do. And I don't want to recommend against it, but it's so hard to predict, where you are, and by the time you're practicing is going to be years away. And I think it's hard to predict what's going to be the next big thing, right? I mean, they say AI is taking over everything now, but maybe 5 years ago, if you would have asked someone, they would have said, oh, we're like light years before like we have anything like, yeah, so it's just hard to know. So I don't know that I would, I think the better bet is to, go through your PhD, go through a postdoc, whatever it is, enjoy what you're doing, build skills, build as much of a network as you can, meet as many people, like start going to conferences. Someone mentioned Bloom Burton before. Just start seeing what it's like to work outside of the academic field, but in the life science field. And then when you show up for those interviews, you'll have a lot of great things to speak about. And I think you'll make a great impression on the person who's your prospective employer at that time.
Thank you.
You're welcome. Are we good for questions now? I think we only have less than 15 minutes to go. I'm just going to quickly flip. I think I have covered most things. I only have a few more slides. But I'll just go back to the slide, and what I was talking about here was what patent agents do, which is essentially the part that's yellow in the background. So we actually help with drafting the patent, getting the patent issued. If you're sort of interested in other things that relate to patents, but not just that process that we call patent prosecution, For example, like a licensing deal. So one company wants to license their IP to another company. Or you'd like to be a litigator, which means someone, looks like someone's making the exact same product that I have a patent covering. I'm going to sue them. Those are also things that IP lawyers do, but not patent agents would do. And those are things that, I do. I get experience to that. I'm not a litigator, but I will support the litigation team, right? Like they might be working with experts, developing their affidavits, and they need kind of subject matter expertise to assist with that. So myself and others in my group here will work with them on that. Although I never actually go to court. Nothing wrong with that. That's just not what I ever wanted to do. And so I stuck to the solicitor branch, where I sit in my office and write documents and send emails and don't go out and shout at people on a regular basis anyways. And so, yeah, so I talked about, I think someone asked a great question, which kind of got me here, like how did my practice evolve to where it is today? And so without repeating myself, as I said, I was doing a lot of IP work, for companies that have a lot of IP, and then started to understand like the market for selling those products, mainly pharmaceuticals when I started, but now I do work with, medical devices, but basically any kind of product that you need Health Canada's approval to sell. I help companies with like, how is your product categorized? And once you're on the market, what are the restrictions with respect to selling it? Excuse me. And sort of through that, I got into, I would say, healthcare generally, right? Like, because if you're thinking about what's the price of a drug, or who pays for it, like how does pharmacies work, like what's this dispensing fee, like all of that stuff is actually in law somewhere. And so through the years of practicing, like I kind of learned how the healthcare system works, which is a lot of my practice these days is advising those institutional clients I spoke of, who they might want to invest in a pharmacy business or a medical practice, and they won't necessarily know the ins and outs of the Canadian healthcare system and how do these businesses even make money? I thought we had public healthcare, right? So I will take them through where you generate revenue in those businesses, what the risks are, because the laws are always changing, and sort of advise them that way, and whether it makes sense for them to invest in those kind of operations. And then I think the last couple of slides, I was struggling to find content here. I think I've covered most of these. This is the slide, all the different products that Health Canada has its hand in. So myself and others in my group will deal with all of those regulation of those products. I think some of this is a little too detailed. Maybe this slide I'll just say, like, if a drug company, like these are the various areas where I would advise a drug company. So like the research and development stage, it's obviously, we're still talking about patents at that stage. At some point in time, they're going to want to run clinical trials. And so you have to apply to Health Canada to do that. You have to enter into agreements with the hospitals. You have to develop consent forms for patients to sign. So again, we work with them on all of that. Pharmaceuticals specifically, like when you do have a patent, there's this whole framework in Canada, in the US as well, where your patent actually prevents a generic product from ever getting their foot in the door with Health Canada. So it not only can you assert that patent if a generic company did start marketing, but what the pharmaceutical patent does is actually prevent Health Canada from reviewing a generic drug submission until your patent has expired. So the generic can't even come to market. So there's a whole framework and strategy around that area of law, and do a lot of work in that area. The market access and reimbursement is what I was talking about in the sense of who pays for the drugs. So we do have rules in Canada at the federal level about what the list price of a drug can be when it's subject to patent protection. And then once that list price is determined, then companies are actually negotiating with public plans and private insurers to give even better pricing, so rebates, so that the effective cost of the drug for the plan sponsor is never what you actually see as the transparent list price. So again, I'll explain that companies, especially if they're US based, they don't understand the Canadian system. So I take them through all those rules and help them with that negotiation process. And then once you do have a product on the market, usually if you're a drug company, you want to advertise, promote. In Canada, direct to consumer advertising is quite limited. So most of the advertising is actually done through, discussions with doctors and having healthcare professionals sort of educate others. Say educate, we don't want to say promote because that makes it wrong, but as long as they're educating others on the drug, those are activities that you can participate in. So again, helping those companies understand what they can and cannot do just from a marketing perspective. I think the last couple of slides I'll just skip over because I think I took some shots from our website on different things we've written on recently and different deals we've been involved in. What I was trying to do here is just give you a sense that even though I started as a patent agent that knew about TGF-beta signaling and nothing else, like now my practice is actually very broad. I'm helping companies like CIBC and M&M Foods, and you never know where you're going to end up was how I wanted to end this. So yeah, if there's any other questions, I'm happy to take them in the last few minutes that we have. But otherwise, I'll wrap it up there.
All right, virtual applause. Thank you.
Thank you.
Thank you, Teresa. If you have questions, you can go ahead and use the raise hand function, and we'll get you to unmute and ask your questions. We got some applause here. Thank you, Enzo.
Thank you.
I had a question while we wait for anybody else. One of the things you mentioned was trade secrets.
Yep.
So what sort of, they're secret. So I guess when you get involved, the secret has gotten out. So what sort of?
No, it was a good question. It's, I would say it more comes up when like I'm doing diligence. So I'm working with a company that's interested in acquiring a company, and they're like, these guys don't have any patents. Is that weird? And it's like, okay, well, let's see what they do. And so then when you see what they do, like, I think the image I had up there was Colonel Sanders, 11 herbs and spices. It's like, well, you don't want to make that public because your whole business model, you got the logo, you got the trademark, but knowing what those 11 herbs and spices are that make KFC so delicious isn't something you ever want to publish. So it's more like saying to them, like, maybe it's not unusual they don't have patents, but maybe you should ask them, they're not going to reveal the secret to you till you buy the company, but you can still diligence what measures do they have in place to ensure that remains a secret. Like I would hope that company would say, well, there's literally only 2 people in the whole company that know what that secret is. We don't let no one can access this database as part of the system. Like it's those kinds of questions. And that's how you sort of figure out, okay, they do have a secret that's worth protecting, and that gives it value.
But would you know the secret in that case, or you would just?
No, I shouldn't. Yeah. I mean, like I can imagine there may be some, like it would be subject to legal privilege and we'd having a discussion about it. But in most cases, I would not know what the secret is, because the whole idea is it's as limited as it possibly can be in terms of who has access to it.
Excellent. I don't see any more questions here in the chat. So I'm just going to go ahead and thank you again for coming and virtually and answering everybody's questions. It was great. Lots of great engagement. And I'm going to remind, sorry, what was that, Teresa?
I was going to say, there's a lot of great questions. So thank you, everybody.
Yeah, clearly we've got a lot of people who are interested in law and IP. I'm just going to remind everybody that there is a link in the chat for the survey for this session and for upcoming sessions to give us an idea of what you liked, what you'd like to see changed, any thoughts you have and suggestions. There's also sections where you can just write things in, so please do that. Volume 2 of the series will be on May 30th, and we're going to have Dr. Kevin Foley, who is a senior scientist at Suolta Therapeutics. And the Zoom link for that session will be on the Nexus website closer to the date, so check back sometime closer to May 30th. It will also be on Tuesday at 11:30, so in the summer, all of the talks will be Tuesday at 11:30. And with that, I'm just going to say thank you, everyone, for coming. And thank you again, Teresa.
My pleasure. Thanks, everybody.